Can the police actually arrest you for looking inside your own car? It sounds absurd. It sounds like the kind of thing that could never happen in Canada, a free country, with a charter, with rights written right into our constitution. But here's the honest answer, and I'm going to give it to you straight. It depends. And I'll tell you right now, most people get this completely wrong. They assume that because they own something, the police simply cannot touch them for it. They think ownership is a force field. That misunderstanding is exactly what gets people handcuffed and tossed into the back of a cruiser at 2 in the morning, standing next to a car they paid for with their own money. So here's exactly what we're covering today, and I want you to stay with me to the end, because the most important part comes last. First, I'm going to walk you through the situation where someone gets stopped right next to their own vehicle, and I'll explain precisely what the police are allowed to do in that moment and what they are not. Second, I'll show you the exact point where a lawful stop turns into an unlawful arrest, and how the wrong words coming out of your mouth can hand the officer the excuse they need to lock you up. And in both of those situations, I'm going to give you the exact phrases to say, word for word, so you protect yourself instead of digging a deeper hole with every sentence. Because here's the truth that no one tells you. The difference between walking away clean and spending the night in a cell very often comes down to a single sentence. The right words, said calmly, at the right moment. Let's get into it. Picture this. It's late at night. A man is standing in a dimly lit parking lot, leaning over and peering into the window of a car. Maybe he locked his keys inside. Maybe he's checking if he left his phone on the seat. Maybe he's just making sure the doors are locked before he walks away. A police officer rolls up, lights flashing, rolls down the window and says, "Step away from the vehicle. What are you doing?" The man, completely confused, says, "Officer, this is my car." And the officer says, "Sure it is. Hands where I can see them. Don't move. Now stop right there." Here is a common misconception, and it's one that trips up almost everybody. A lot of people genuinely believe that the moment they say the words, "It's mine," the officer is legally required to back off, apologize, and walk away. They think ownership is a magic shield that ends the conversation instantly. It is not. And I need you to really understand why, because this is where people get themselves into trouble. The officer doesn't know it's your car. They can't see the registration. They can't read your mind. From the outside, at night, a person leaning into a car window looks exactly the same, whether they own that vehicle or whether they're 30 seconds away from breaking into it. The officer is reacting to what they see, not to what's true in your heart. So your job in that moment is not to win an argument. It's to manage the situation calmly and legally. So what is the officer actually allowed to do here? This is where you need to understand a concept called investigative detention. In Canada, the Supreme Court of Canada set this out in a landmark case called R.V. Mann, decided in 2004. In that decision, the court recognized that police have a common law power to briefly detain a person. And I want you to hear that word carefully. Detain, not arrest. If they have reasonable grounds to suspect that the person is connected to a recent or ongoing crime. That's a real specific legal standard. It's not, "I felt like it." It's not, "He looked sketchy." It's reasonable suspicion based on objective facts. So think about the scenario. A person leaning into a car window, late at night, in an area where maybe there have been a string of vehicle break-ins recently. In those circumstances, an officer stopping you and asking you to explain yourself can be perfectly lawful. I know that's not what you want to hear, but I'm not here to tell you what feels good. I'm here to tell you what's true, so you don't make a costly mistake. But, and this is absolutely critical, a detention is not a blank check. It is not unlimited. The charter places hard limits on what the police can do, and the second you understand those limits, you understand your power in that moment. Two things kick in immediately. First, under Section 9 of the Canadian Charter of Rights and Freedoms, you have the right not to be arbitrarily detained or imprisoned. That word arbitrarily matters enormously. It means the officer needs an actual articulable reason, not a hunch, not a gut feeling, not, "I just didn't like the look of him." If there's no reasonable basis for the detention, then the detention itself may be a charter violation. Second, under Section 10A of the Charter, you have the right to be informed promptly of the reasons for your detention. The Supreme Court reinforced exactly this in another case called R.V. Subaru, decided in 2009. The police cannot just hold you in limbo, refusing to tell you what's going on, letting you stew in anxiety while they decide what to do. They have to tell you, in clear and simple language, why you are being held. That is your right, and it's backed by the highest court in the country. So here's the exact phrase I want you to memorize and use. Stay calm. Keep your hands visible. Don't reach into your pockets. Don't make sudden movements. Don't give anyone a reason to feel threatened. And then say, "Officer, am I being detained? And if so, what is the reason?" That one sentence does two powerful things at the same time. It forces the officer to commit, out loud, to a legal basis for holding you, and it signals, calmly and respectfully, that you understand your rights, without being aggressive or confrontational. Officers behave very differently with someone who is composed and informed versus someone who is panicking or yelling. If the officer answers that you're being detained because someone reported a possible break-in, now you actually understand the situation. The fear drops away because you know what's happening. At that point, you can simply say, "This is my my vehicle. I'm happy to confirm that. Now here's a point that varies a great deal depending on exactly what you're doing, and I want to be precise about it because people get this wrong constantly. If you are the driver of a motor vehicle, meaning you've actually been pulled over while driving, the rules about identifying yourself are different and stricter. For example, in Ontario, under the Highway Traffic Act, a driver is legally required to identify themselves and produce their license when an officer requests it during a lawful traffic stop. Every province has its own equivalent traffic legislation with similar requirements. So if you're behind the wheel, refusing to identify yourself is generally not an option, and trying it can land you in real trouble. But standing in a parking lot, not driving, simply looking into a parked car, that is not the same situation at all. Outside of operating a vehicle, there is generally no law in Canada that forces you to carry identification or to identify yourself to police merely because they ask, unless you're being lawfully arrested, or you fall under a specific provincial requirement that applies to your circumstances. I see people make this mistake all the time. They assume they are legally obligated to hand over ID in every single interaction with police, no matter the context. That is simply not accurate as a blanket rule, and the precise answer depends on your province and the exact facts of the encounter. So when you're not sure, stay calm, ask why you're being detained, and if it's serious, speak to a lawyer before you assume you have no choice. The key takeaway from situation 1, before we move on, a brief investigative detention can absolutely be lawful under RV Man. Ownership does not automatically end it, and your single most important job in that moment is to stay calm and force the officer to state the actual legal reason for holding you, using that exact phrase I gave you. Now let's move to the part that turns into a lawsuit headline, the part where things go badly wrong. Same man, same parking lot. He's stayed calm. He's confirmed it's his car. He's even offered to prove it, but the officer is frustrated. Maybe it's the end of a long shift. Maybe the officer has already decided how this is going to go. And instead of de-escalating, the officer escalates. He grabs the man, spins him around, puts him in handcuffs, and arrests him for, let's call it, suspicious behavior. The man is driven to the station, booked, fingerprinted, held in a cell for hours, and then released the next morning with no charges whatsoever. Nothing. He's just let go like it never happened. So the question is, was that legal? And this is where ownership, the charter, and the real limits on police power all collide. This is exactly where police can cross the line into territory that gets them, and their department, sued. An arrest is a fundamentally bigger deal than a detention. A detention is brief and limited. An arrest is a full deprivation of your liberty, and the law treats it with far more seriousness. In Canada, a peace officer's power to arrest someone without a warrant is governed by Section 495 of the Criminal Code. That section sets out specific conditions. It says, among other things, that an officer may arrest a person without a warrant if they find that person actually committing a criminal offense, or if the officer has reasonable grounds to believe that the person has committed or is about to commit an indictable offense. I want you to notice the language there, because it's everything. Reasonable grounds. Not suspicion, not a feeling. Reasonable grounds. A higher standard than the reasonable suspicion needed for a brief detention. And here's the killer point. Suspicious behavior on its own is not a criminal offense. There is no section of the criminal code titled looking suspicious. Looking into your own car is not a crime. So if the officer had no reasonable grounds to believe an actual criminal offense was being committed, that arrest may well be unlawful from the very start. And here's where even more of your charter rights come into play. The moment you are arrested, Section 10A still applies. You must be told the reason for your arrest, promptly and clearly. But now Section 10B also activates, and this one is huge. You have the right to retain and instruct counsel without delay, and to be informed of that right. That is your right to a lawyer. The Supreme Court has made clear that this right activates immediately, not after they've questioned you, not after they've gotten what they want, but right away. There's also Section 8 of the Charter, which protects you against unreasonable search and seizure. This is enormous in these situations. If the officer starts going through your pockets, your bag, or begins searching your vehicle without a lawful basis to do so, that can be an entirely separate charter violation stacked on top of the unlawful arrest. A search has to be authorized by law and carried out in a reasonable manner. Police don't get to search you just because they've decided to. So what do you actually say when you feel a detention tipping over into an arrest? When the tone shifts, when the cuffs come out, when you sense this is going sideways, here is your exact phrase. Memorize it. I do not consent to any search. I am exercising my right to remain silent, and I want to speak to a lawyer. Say it calmly. Say it clearly. Say it once. And then, this is the hard part, stop talking. Just stop. Here is a common misconception that destroys people. They think that staying silent makes them look guilty, so they keep explaining, they keep arguing, they keep insisting, but it's my car, you can't do this is ridiculous. I see people make this mistake all the time, and I'm telling you, it is the single most damaging thing you can do in that moment. Everything you say can and will be used against you later. You do not talk your way out of a bad arrest at the side of the road. It does not happen. The officer is not going to suddenly say, "Oh, good point, you're free to go," because you argued well. You protect yourself by invoking your rights, staying silent, and letting a lawyer handle it properly afterward, where the real fight happens, in front of a judge, not in a parking lot. Now let's talk about that $5 million lawsuit in the title, because I owe you complete honesty here. Can you sue the police for a wrongful arrest in Canada? Yes, that is genuinely possible. Canadian law recognizes civil claims like false imprisonment and false arrest, and a breach of your charter rights can support a claim for damages against the police. So this is not a fantasy. People do bring these cases, and people do win them. But I'm going to be straight with you, because accuracy is the whole point of this channel. I am not going to invent a dollar figure or promise you any particular outcome. Whether a lawsuit succeeds, and what it might be worth, depends entirely on the specific facts of your case, what the officer actually knew at the time, whether they genuinely had reasonable grounds, what harm you actually suffered, and the law as it applies in your particular province. And here's a dose of reality. Damage awards for these kinds of claims in Canada are usually far more modest than the dramatic seven-figure numbers you see splashed across headlines. That doesn't mean your case has no value. It means you should not walk around with a fantasy number in your head. So if you genuinely believe you've been wrongfully arrested, here's what actually matters. As soon as you possibly can, write down everything you remember while it's fresh. The time, the location, what was said, what was done. Get the names and badge numbers of the officers involved if you're able to. Note any witnesses, any cameras nearby, anything that could corroborate your account. And then speak to a lawyer in your province who handles these claims. Do not rely on a YouTube video, including this one, to tell you what your case is worth. That's not what this is for. This is to help you understand your rights and protect yourself in the moment. Let me bring this all together in 3 simple points so it sticks with you. Number 1. Owning something does not automatically end a police interaction. Under R.V. Mann and Section 9 of the Charter, police can briefly detain you on reasonable suspicion. So your move is to stay calm, keep your hands visible, and ask, "Officer, am I being detained? And if so, what is the reason?" Number 2. A detention is not an arrest. An arrest requires reasonable grounds under Section 495 of the Criminal Code, and suspicious behavior by itself is not a crime. The moment things escalate, invoke your Section 10B right to a lawyer and say, "I do not consent to any search. I am exercising my right to remain silent, and I want to speak to a lawyer." Then stop talking. Number 3. You can pursue a civil claim for a wrongful arrest in Canada through claims like false imprisonment, but the value and the success of that claim depend completely on the facts and on the law in your province. Document everything and talk to a real lawyer before you believe any number you see in a headline. Save this video so you have these exact phrases ready the moment you need them. See you in the next one.